Welcome to Dolly Talk. This is Dolly. How is everybody doing? Don't know why the camera's all like glary. There we go. Oh, how is everybody doing? F Irish is here. Good to see you. Brad. Late in Dolly Talk. Yes, I know. Well, it's only 1 minute late. Paul is here. Let's go, Scott. Here for the free cough. Carla, nice to see you. And Maddie. Louise. Thomas, how you doing? Got Knit a Wow here. So we are going to start closing arguments of the James Ogletree trial. And it's pretty good so far. To me, not as much reasonable doubt as I saw in the Cummings trial. But some of the jurors are pretty based with their questions. So we shall see. We shall see. Why are people calling me? Good Lord. I suppose the bigger question is, why is my phone on? But that's okay. We'll just ignore that. And go ahead and proceed here.
Yes, sir.
Okay, so we'll come back at 12:30 then and restart. Okay.
All rise.
Peeks out of the.
Okay, so he gave the jury instructions to the jury.
Ladies and gentlemen, you've now heard all of the testimony and evidence in this case. Let's talk about what we know the facts to be from what you've heard during the course of this trial.
I should probably move.
At 6:59 p.m., James Ogletree and Anthony Cummings meet up on the first range of J Block, spend a couple of minutes walking and talking. At 7:04 p.m., marked on December 6th of 2023, Marquise Wetherington can be seen for the last time alive on surveillance camera, peeking out of his cell, 2J3, at Lebanon Correctional Institution in Warren County, Ohio. Seconds later, Anthony Cummings and the defendant, James Ogletree, can be seen entering cell 2J3 and sliding the door shut. At 7:11, Vincent Wicker knocks on the door of cell 2J3 after having been asked to be a lookout. Mr. Cummings, in response to that knock by Vincent Wicker, peeks out of the cell 2J3 twice in quick succession, checking out the surroundings.
Peekaboo.
At 7:11 and 7:13, Shaquiz Hakeem looks into the cell. And he told you that he saw Mr. Wetherington on his back on the bottom bunk with the defendant on top of him strangling. And he told you that he saw Anthony Cummings throwing some punches as well as going back and forth to the door like a lookout.
Also, before we get into it, MLS is doing a trial at 9 p.m. Eastern, Michigan trial. I will redirect you over there, assuming you're still doing it. That should be interesting.
At 7:14, Anthony Cummings leaves with Marquise Wetherington's commissary bag, takes it to a cell on the other side of the range, and returns at 7:17. As Mr. Cummings is completing that task, the defendant is alone in cell 2J3 with the victim. And we know that Mr. Wetherington's commissary bag was never recovered. Moments later, Anthony Cummings and James Ogletree leave cell 2J3 and head in opposite directions. And at this time, blood is visible on the defendant's pants. The defendant and Mr. Cummings can be seen having multiple conversations shortly after they leave cell 2J3. First, here on the top range, Mr. Wicker, and then walking and talking on the bottom range. After the defendant and Mr. Cummings leave cell 2J3, 40 minutes go by before Mr. Weatherington's cellmate, Jason Addison, returns to the cell at 7:57.
Feel free to pop
And he
on,
told
David.
you that he returned to his cell at that time because he had been approached by Anthony Cummings, who told him that he needed to check on his cellie because we beat his ass. You can see that conversation occur on surveillance video. And Jason Addison finds Mr. Weatherington face down on the floor, naked from the waist down, apparently unconscious, and his cell's a mess. And he immediately leaves. He doesn't know what to do, and he tells you he's not trying to have any part in what's going on.
No.
11 minutes later, approximately, at 8:07, Jason Addison calls his girlfriend. A phone call that you heard, freaking out because people went into his cell and fucked my cellie up. Mr. Addison is again approached by Anthony Cummings, trying to check on the status of the victim. Mr. Addison told you he declined to clean the cell up for him, but agreed to help move Mr. Weatherington. So off to cell 2J3, they go at 8:12. Anthony Cummings and Jason Addison. They try to wake Marquise Weatherington up, which fails. And while they do get him onto the top rack, as Jason explained to you, Marquise never came to. He never woke up. He never was responsive. And while Mr. Addison admits he did not make much inquiry into how Marquise Weatherington was doing, he told you that he never knew him to be responsive or move around again after he entered the cell at 7:57. Consider Mr. Addison's appearance as they leave the cell at 8:15. Does that look like someone who just came from a cell where everything is fine? Lockdown is at 9 p.m. And while Mr. Addison tells you he attempts to alert a CO, corrections officers are not notified until approximately 7:42 a.m. on the morning of December 7th, when Corrections Officer Tyler Lay and Corrections Officer Jimmy Potts, after being alerted by inmate Glenn on the second range, find Marquise Weatherington unresponsive in the top bunk, which is covered in blood. We know that Marquise Weatherington was pronounced deceased at approximately 8 a.m. by Captain Corey Girdman. And we know from the autopsy that Marquise Weatherington suffered multiple blunt force injuries to his head, neck, chest, abdomen, and extremities. We also know that Dr. Brown found evidence of strangulation, a fact that was corroborated by what Shaquiz Hakeem told you he saw occurring in cell 2J3 as the defendant is over top Marquise Weatherington. And we know that the victim's DNA was found on both the defendant and Anthony Cummings on the clothing that they can be seen wearing in the surveillance footage. And as a result of all of those facts, James Ogletree is charged with 3 counts: felony murder, felonious assault, and aggravated robbery. In count 1 of the indictment, the defendant is charged with murder. Judge Teep is going to tell you that the state must prove beyond a reasonable doubt that on or about December 6th in Warren County, Ohio, the defendant caused the death of Marquise Weatherington as a proximate result of committing a violent felony, in this case, felonious assault. But before you can render a verdict on count 1, murder, you must first decide your verdict on count 2, felonious assault. Because remember, as we talked in voir dire, the defendant is not charged with purposeful murder or premeditated murder, but that felony murder. The death results from the commission of a violent felony. So let's look at the violent felony. In count 2 of the indictment, the defendant is charged with felonious assault. The state must prove to you beyond a reasonable doubt that on or about December 6, 2023, Warren County, Ohio, the defendant knowingly caused serious physical harm to Marquise Weatherington. or he was complicit in causing serious physical harm to Mr. Wetherington. The judge is going to tell you that the defendant, for complicity, the defendant knowingly solicited, aided or abetted, or conspired with another to commit the offense of felonious assault. So you can find that the defendant committed the offense of felonious assault, or you can find that he aided and abetted his co-defendant, Anthony Cummings, in the commission of the offense. Remember the example from voir dire of all of the participants of a bank robbery, not just the guy with the gun at the bank teller's head. The state doesn't have to show you that the defendant was the primary aggressor or the one that inflicted the most harm. Under complicity, you must find the defendant guilty of felonious assault if you find that he aided or abetted Mr. Cummings in the commission of a felonious assault. And what is the
Even
definition?
though a jury already
for
found him
aided
not
and
guilty?
abetted?
I mean, come on.
The judge will tell you that it means that he supported, assisted, encouraged, cooperated with, advised, or incited the principal offender to commit the offense. And the defendant has to share the criminal intent of the principal offender, which means the defendant knowingly aided or abetted Mr. Cummings. A person acts knowingly, regardless of purpose, when the person is aware that the person's conduct will probably cause a certain result or will probably be of a certain nature. And knowledge is determined from all of the facts and circumstances in evidence.
Nidwau. Oh, you're
The
here.
state does not have to prove that.
She can say almost everything she wants to say about Cummings. So it doesn't matter at all that he's been found not guilty. I mean, she can still say he was also involved in the murder, and there's no like limits to what she can talk about here.
That anyone acted with the specific intent to cause a felonious assault. Only that they knew their actions could cause a certain result.
Gotcha.
The judge will tell
This is
you
argument. Okay.
that you can infer
That makes sense.
the knowingly aspect from the circumstances surrounding the offense, including but not limited to presence, companionship, and conduct before or
no worries,
after
Louise.
the offense was committed. When you are present and participating in the kind of assault that obviously occurred in this case, based on the findings of Dr. Brown and the autopsy that was conducted, the defendant and Mr. Cummings would certainly have been aware that the result of their conduct could be serious physical harm. Serious physical harm means any of the following. Any physical harm that carries a substantial risk of death, any physical harm that involves some permanent incapacity, whether partial or total, or that involves some temporary substantial incapacity, and physical harm that involves acute pain of such duration as to result in substantial suffering, or that involves any degree of prolonged or intractable pain. Knowingly cause serious physical harm. We don't need to prove that the defendant intended to cause serious physical harm, or that he knew Anthony Cummings intended to cause serious physical harm. Only that he was aware that his actions or those of his partner could result in serious physical harm. And it's important to remember we're talking about knowingly committing or being complicit in the commission of a felonious assault. The serious physical harm, not the death of Mr. Wetherington. Ladies and gentlemen, you've seen the photographs of the victims' injuries.
So Nidwau says, I mean, it's a little shady to be saying Cummings over and over, but Brenner isn't going to object. Yeah, because I mean, he wants the jury to think that it's that Cummings was the one who did it. and he's just going to contest that Ogletree, his client, was involved. So he's not going to object. And Cummings' attorney is probably over in another county court picking up new cases. So it feels really weird to just hear them continue to say he was involved. I think Half Irish was the one that pointed that out. Well, she said Tree over and over in Cum Dog's trial. She did, but Ogletree hadn't yet gone to trial. So he'd not been acquitted or convicted.
Heard the coroner lay out the list of injuries the victim suffered at the hands of the defendant. This wasn't a one-punch situation.
There, Johnny.
This wasn't quick. This was a brutal attack. And there is no question that the defendant and Mr. Cummings caused serious physical harm to the victim. And remember, the state doesn't have to show that the defendant was the primary aggressor or the only one that inflicted harm. Under complicity, you must find the defendant guilty of felonious assault if you find that he aided or abetted Mr. Cummings in the commission of a felonious assault. Here's what the evidence shows. The defendant and Mr. Cummings meet up on the first range at approximately 6:59 p.m., where they start talking, a conversation that lasts for a couple of minutes and includes a stop at a corner behind the stairs. The defendant and Mr. Cummings go into cell 2J3 together. Shaquiz Hakeem observed the defendant strangling Mr. Wetherington, and he observed Mr. Cummings throwing some punches. When Mr. Cummings approaches Mr. Addison to tell him to check on his cellie, he tells him, "We just beat his ass." Not he, not they, not me. We. The defendant is in the cell for approximately 13 minutes. 2 minutes and 16 seconds of that, he is alone in cell 2J3 with the victim. Remember, this was a brutal assault. This was not quick. Mr. Wetherington suffered blunt force trauma to nearly his entire body. And while the defendant is alone in the cell with Mr. Wetherington, his partner steals Mr. Wetherington's belongings. Shaquiz Hakeem told us that Mr. Cummings was a lookout. In between the punches, he'd go look out the door. Surveillance video confirms that. You can see him stick his head out a couple times, making sure they weren't going to be interrupted and they weren't going to be caught. He also waits for the okay from Mr. Wicker before leaving the cell. Why would one need to be a lookout but to ensure that what was occurring in the cell was not discovered? No question that when looking at all of the evidence together, the defendant committed the offense of felonious assault. You're not being asked to find whether the defendant was guilty as a complicitor. Complicity is merely a theory to assist you in your analysis of felonious assault. The judge is going to tell you that a person who is complicit with another in the commission of a criminal offense is regarded as guilty, as if he personally performed every act constituting the offense. This is true even if he did not personally perform every act. If you find the state has proven beyond a reasonable doubt that the defendant committed or was complicit in the commission of the felonious assault, then your verdict on count 2 must be guilty. So then we go back to count 1, felony murder. The only real question left for you to decide is whether the harm suffered by the victim as a result of the felonious assault was the proximate cause of his death. One way to look at felonious assault or felony murder is like an equation. Felonious assault plus a death equals felony murder.
Oh my
The
God.
death has to be a result of the harm suffered during the felonious assault.
Can we charge you with
In this
boring the
case,
jury to
there
death?
is no question that the victim ultimately succumbed to the injuries he suffered at the hands of the defendant and Mr. Cummings. You heard testimony from Dr. Brown that clearly establishes that. She testified that he suffered from multiple blunt force injuries to the head, neck, torso, extremities, and showed significant signs of being strangled. The effect of the constellation of injuries resulted in the death of Marquise Weatherington. So if you find the defendant guilty of felonious assault, then he is also guilty of felony murder. Remember, this is not premeditated murder. It's not purposeful murder. And nowhere in the judge's instructions to you will you be required to hold the state to that standard. The state doesn't have to show that the defendant knowingly caused the victim's death. Only that they knowingly caused serious physical harm. And that serious physical harm resulted in the victim's death. In count 3 of the indictment, the defendant is charged with aggravated robbery. Judge Cheap will tell you that the state must prove beyond a reasonable doubt that on or about December 6, 2023 in Warren County, Ohio, the defendant, while committing or attempting to commit a theft offense or in fleeing immediately after committing a theft offense, inflicted or attempted to inflict serious physical harm on Mr. Weatherington. The evidence has already clearly established the serious physical harm piece. So the only real question is, was a theft offense occurring? The evidence shows that on the evening of December 6th, Anthony Cummings took the victim's belongings and put them in a cell. Meanwhile, as Mr. Cummings is stealing Marquise Weatherington's property, the defendant is alone with the victim in his cell. You don't see Mr. Weatherington attempt to follow Mr. Cummings out, prevent him from leaving the cell, because he was unable to do so due to the physical assault he was suffering at the hands of the defendant who remained behind. Mr. Cummings never returned that property. You heard from the Highway Patrol it was never recovered. He didn't return it when the fight was over, not when he goes back into the victim's cell later, not the next morning. That's a theft offense. Ladies and gentlemen, the state has met its burden and proven all of the elements of all 3 counts of the indictment to you beyond a reasonable doubt. Based on all of the evidence presented, the state is asking that you hold James Ogletree accountable for his actions on December 6th of 2023 that resulted in the death of Marquise Weatherington and return a verdict.
Thank you, Ms. Nicholson.
All right, come dogs up. So, Paul, you did raise a good point. Why wasn't this a manslaughter trial? Not a lawyer, but I do know quite a few. Basically, a lot of prosecutors, especially nowadays, have started relying on felony murder because the instructions and it's a lot easier to prove compared to like murder where you have to actually prove someone with the intent. I just play one on YouTube. Exactly. Manslaughter, you still have to kind of prove that there was something reckless going on. You'd have to prove that he beat him up. I believe they're just saying because he stole the bag. Aggravated robbery of cups of soup. But basically they're hanging their hat on the fact that during the commission of that theft, getting his stuff back, he died. It's basically, it's a lazy route, but aggravated is the violence. Yeah, that makes sense. So it's just an easier way of getting to murder. It's a good question.
Apologies, Your Honor. Just need to.
You're on.
Oh, good Lord.
Ladies and gentlemen of the jury, I'm sorry about that. I'm having a little throat tickle issue. Try to work through
That's
it.
a great time to have that.
So I talked to you at the very beginning of this case
Violent
about reasonable
phone call.
doubt and the burden of proof, right? As we sit here, right, we do not have to prove anything. The state has to prove each and every element of the offenses that Ms. Nicholson just outlined here. They have the full burden. So let's talk about what we've seen, what we've learned over the last couple of days. I think the one thing that virtually every witness agreed on, all the inmates, the EMTs, the medical staff, the highway patrol, is that Lebanon Correctional is a violent place. I believe Mr. Addison himself said, we live in hell, or that may have been Mr. Wicker, one of his two. Somebody said we live in hell.
Oh my God,
Hakeem and Addison said it was the most violent prison that they've been in. We heard reference.
Way to sell how violent this place is. Well, somebody said, I think it was him. Well, maybe it was him who said it was hell. I don't know. Somebody said it was hell, but you know, it's a bad place, you know. Wow. Okay.
To daily fights, assaults, robberies, beatings, drugs, highway patrol. They said they respond hundreds of times. EMTs, he just indicated he just completed a report, over 70 calls per year. And that's a high level. That's just to the point where the EMT is responding, as you heard him testify. There are such a medical emergency that the on-site staff can't handle that. Right. So we're talking about more than once a week. Right. We heard testimony about gang presence in the facility. Notably, we heard that Wicker and Addison are in the same gang. I think it's notable. Addison testified he had just been released from the whole segregated housing. That's where you're placed for disciplinary reasons. Since this incident, he testified he's been transferred to a higher level security facility due to misconduct. I want to point your attention also, we heard quite a bit of testimony about the culture of silence, snitching, the ramifications of that, the consequences of that within the facility.
Culture of silence makes it sound like a Lifetime movie.
So if we look at the night in question, and you're going to have all the exhibits available to you. But if you look at the night in question, the very beginning of the second chunk of video, there's the chunk from 4 p.m. to 7 p.m. Then there's the chunk from 7 p.m. through the next morning on the surveillance video. Right around 7 p.m., we see the defendant, Mr. Ogletree, walk directly past Mr. Wetherington. Mr. Wetherington standing in the doorway to his cell. There doesn't appear to be any animosity. Doesn't appear, again, we don't have audio, but there doesn't appear to be any words exchanged, right? There's no stare down, right? There's no posturing. And the state would have you believe that just mere minutes after Mr. Ogletree harmlessly walks past him, right? He's then in the cell assisting in beating this man, ultimately what would be to his death. Right, there doesn't appear, we heard no testimony, there's no provocation, there's no issues between them, there's no problems, right? And again, I just want to point to that part of the video because I feel like it's extremely significant. Again, there's no encounter at all. It's just like any other two people on the range passing each other, right? And notably, who does not do anything like that, who you will not see on this video, crossing paths with Wetherington until he enters the cell, Anthony Cummings. And again, you will have these exhibits available to you. You will pay attention, listen carefully. At 7:04:33, Cummings enters the cell first. We have seen the dimensions, or I think Trooper Creech testified to the dimensions of his cell, 6 by 10. We've got plenty of pictures of that cell. We've got beds on the one side. There's a shelving unit there. Right? These are 3 grown men. Cummings enters first, right? There are pictures of that back corner of the cell. There's blood on the floor. There's a loose dreadlock. We don't know whose dreadlock that is. Why don't we know whose dreadlock that is? The highway patrol never bothered to recover it. They took a picture of it. They just let it lay there, right? Take a look at State's Exhibit 47, the picture of Anthony Cummings. Look at his hair. Again, all of these individuals had dreads.
Should have this guy
We would put
prosecuting
it to you that the
Cummings.
most rational explanation of what happened inside of that cell, Cummings enters first. Cummings and Wetherington immediately make contact. They're in an altercation that ends in that back corner of the cell, where it is the kind of altercation that ends in somebody's dread being pulled or ripped out of their head, right?
The dread don't fit.
Ms. Nicholson just argued that you can see Mr. Cummings in the doorway to the cell. We do not agree. I think it's not clear who that is. It's someone, right? It may be Mr. Ogletree. It may be Mr. Cummings. It could be Mr. Wetherington. We don't know. It's not clear because all you see is the barest glimpse of a profile and maybe a little bit of hair. It is not clear who that person is. I think it is most significant, right? We agree with the state that a robbery took place and that Mr. Cummings had accomplices. The question is, who were those accomplices, right? Cummings is the one who takes the property. Not only does he take the property, he pretty much immediately, you can see it on the video, he pretty much immediately pays out his accomplice, Mr. Wicker. Mr. Wicker testified he got paid that day, same day. You know who didn't get anything? Mr. Ogletree. So the state would have you believe that this was an orchestrated robbery, that one of the primary participants somehow didn't get paid, right? Does that make sense, right? There are two people who point the finger at Ogletree. Mr. Cummings, Mr. Akeem. We heard testimony from Mr. Akeem. Number one, he doesn't even remember, right? His testimony was discussed with him by the prosecutor. He was shown his earlier statement on a video, and he testified to that. He doesn't even remember what took place, right? But what he does remember is that he was Cummings' friend, right? The state would have us believe, right, that if we listen to what Mr. Addison said, that there was a board. He said that's some kind of a cover over the window, right? A shirt, a box, something. I think actually in one of the pictures, you can see the door to 2J2. It's got like little Debbie boxes up over it, right? Because you need a little bit of privacy. As you saw, the toilet's right inside the front, right? But so they would have us believe that for some reason, while this robbery is taking place, no one bothered to cover the door, but then it's covered up later on, right? It's conveniently not covered up just in time for Mr. Addison, or I apologize, Mr. Akeem, to look inside and to be able to conveniently demonstrate that, hey, it wasn't his friend who actually beat this guy up. It was Mr. Ogletree, right? Notably, when we talk about, accomplices and the robbery, not only is Mr. Wicker an accomplice here, right? He's the one who looked out, he knocked on the door, he instructed someone else to knock on the door. He got paid out some of these food items. Mr. Addison is an accomplice. And the state would have us sit here and rely on the statements of Mr. Addison as if he is completely reliable, as if he did not destroy important evidence that was never recovered, right? We don't know what was taken to that trash can. We simply don't. It was never found. Right? There is no bedding on his bed, right? No blanket, no pillows. We see him on the video walking some kind of I don't know if it's a blanket with other stuff wrapped in it. We don't know what it is because nobody ever found it, right? We see them walk that down, and who's on the other side of the range? Conveniently the next morning, Anthony Cummings. Who's nowhere to be found?
Convenient.
Mr. Ogletree, right?
They found Cum Dog
So
in
this
jail.
scheme here, right? We have Akeem, we have Cummings, we have Addison, we have Wicker, right? Mr. Ogletree, pay attention to his statements. The state is going to argue that these statements are some kind of a lie, some kind of a story that he made up. I'm going to put it to you this way, right? There is a culture of silence in this prison, right? There are ramifications for pointing the finger at somebody, for snitching, right? Mr. Ogletree is desperately trying for about an interview and a half to avoid pointing the finger at anybody, right? He doesn't know what happened. They were tuning, they were epping, whatever.
They were effing.
But we heard testimony from more than one witness, from the coroner who did the toxicology report, from Trooper Creech, that tune can be any number of things.
Hey, Matt.
It may not be
yeah.
possible for that to show up. It might just be bug spray on paper. It may not be possible for that to show up on a toxicology screen. The state would have you dismiss any tune use, any drug use as impossible because there's nothing on the toxicology screen, right? But they're in that cell. Right? We don't know what happened in the cell. The people who know what happened in the cell, Mr. Ogletree, Mr. Cummings, who's not here, Mr. Weatherington, who's tragically deceased, right? We don't know what happened. Here's what we know, right? Around 7:04, Mr. Cummings, Mr. Ogletree enter the cell. Mr. Ogletree, Mr. Cummings exit. Mr. Cummings exits at around 7:11. Mr. Ogletree exits several minutes later, right? And then about 40 minutes after that, Mr. Cummings, Mr. Addison enter the cell, right? And then ultimately the next morning, dispose of something, right? We don't know what that is. What we don't know, it's never been able to be established, right? Is cause of death or the time of death, right? And what time these injuries were inflicted. Right? We simply don't know. We don't know because Mr. Addison decided, I'm just going to sleep in this cell all night and not tell anybody, right? We see on the video how many times there are COs walking past, right? It's a completely separate individual who finally alerts the staff, right? Hey, there's something wrong up here. I'm going to point your attention to around 7:03 a.m. You can see Mr. Addison is standing in the door to his cell. A CO walks directly past him. He doesn't say anything, right? And again, I want to circle back to Mr. Ogletree's statements, right? He's talking about tune use, right? And I would argue that when we look at, those statements, we look at the video, right? We look at the fact that right around 7 p.m. before they enter the cell, he just walks past Mr. Weatherington, like nothing's going on, right? That he and Mr. Cummings are talking about using tune in that cell, right? There's nothing to indicate that never happened, right? There's nothing. And I would argue, right, we look at the first statement, the December 7th statement, and he's talking about lunch. I believe it is possible that lunch and dinner were mixed up, right? You're in prison. This was shortly after CHOP, as multiple inmates and staff indicated, right? You're in prison, the days run together, you mix up your meals. It happens, right? The second day, right? The second statement, I really want to point your attention to the second interview, right? Mr. Ogletree is consistently, I counted on about 12 different occasions throughout the transcript. Mr. Ogletree consistently talks about there being dreads on the floor. He tells the investigators that there is a dread on the floor. We know that. We've seen it. It's in the photos, right? They never follow up on that, right? That is a consistent statement with the evidence in the case that was never followed up on, that was never investigated. It is the responsibility of law enforcement to investigate these cases and the responsibility of the state to present them in court like we're doing here today, right? There was evidence in this case that was not followed up on, right? It wasn't investigated, right? That dreadlock could have very easily been sent off to BCI to be tested, right? It's laying in blood. Then look at the picture of Mr. Cummings. Look at the dreadlock on the floor, right? Ultimately, Mr. Ogletree, again, not only is he talking about dreads, he's talking about how he stuck around to try to help, right? The state's going to have you believe that this was some kind of an orchestrated robbery that didn't ultimately result in Mr. Ogletree receiving anything, right? Where Mr. Ogletree, his story is that he went into the cell to smoke tune, right? Somebody gets hurt, he helps out. He's not trying to get in any trouble. He's not trying to get anybody else in any trouble. He's trying to go along to get along, right? Which again, more than one inmate referred to this place as hell, right? Going along to get along seems like a pretty good strategy for survival in a place like that, right? He's got blood on him. He helped Mr. Wetherington, right? He's in the cell. He's getting him up, getting him around, whatever. We don't know what happened. We don't know how severely or not severely he was beaten. We don't know if he fell. What we do know is that there's a dent on that shelving unit, which appears to be some kind of metal, right, with some blood splatter on it. There's blood in that back corner, right? It's kind of like a little splayed out pattern, right? Did he hit his head on the floor? Did he hit his head on the shelf, right? Mr. Addison, who again covered up quite a bit of evidence, so I'm not sure why we should just rely on everything that he says is accurate. But Mr. Addison said that he found him at least naked from the waist down. He said he didn't remember what he was wearing, but naked from the waist down on the floor, right? Is it possible that Mr. Wetherington got up to use the bathroom? Because again, there was an indication that the door was covered up and fell and hit his head. We don't know. Because again, the coroner's not able to establish what time these injuries took place. There are multiple people in this cell. Mr. Cummings, who again is the one who actually robbed Mr. Wetherington. Mr. Cummings goes back in the cell and he's in there for a number of minutes, right? Mr. Addison testified, hey, we're gonna move him up on the bed. Why are they moving him up on the bed instead of getting help? To cover up what happened, right? Again, Mr. Ogletree received no property. No one testified to that. No one recovered anything. No one found anything in his cell. In his statement to investigators, he indicated he doesn't need to rob anybody. If he wants some food, he'll just ask somebody for it, right? The state would have you believe, again, that he participated in this robbery that resulted in Mr. Wetherington's death without actually getting anything out, right? So that would lead us to conclude, right, that either Mr. Ogletree is completely incompetent or he's roughly an innocent bystander in all of this, right? The state
I can go with the incompetent.
I'm sure you're going to hear it again, right? The bank robbery example, right? That the individual, the getaway driver, is just as guilty as the people in the bank, right? Let's elaborate on that, right? So if this is a bank robbery, Cummings is the one who took the stuff out of the safe, right? Addison is the bag man helping clean up after the fact, right? Wicker's the lookout. And Akeem is the alibi guy, right? Hey, he didn't do it. Ogletree did it. Yeah, my buddy, he's innocent. He wasn't doing anything in there. Right? What the state has demonstrated that Mr. Ogletree is guilty of is being in that cell and having blood on his clothes. Again, we don't know what caused those gashes to the side of his head. We don't know what caused these injuries. We simply don't. And the reason is, again, because he was in that cell for 12 hours. Right? Mr. Addison says he was completely non-responsive when he went in the cell. And Mr. Addison, again, admitted to being a gang member, right? Also destroyed, disposed of, covered up quite a bit of evidence. And ladies and gentlemen, the jury, ultimately, right, the actions that the state is going to present as suspicious, right? Mr. Ogletree walking around talking to Mr. Cummings, right? He's walking around the block. You see him talk to a large number of people. Ultimately, all of his actions can be explained, right? If we just assume that he's going in that cell to smoke tune, right? We heard that's banned. Right? You get in trouble administratively, you get charged with a felony for that, right? Trooper Creech testified about his role in investigating drug possession, right? That is also illegal. And that can explain virtually all of this suspicious behavior beforehand. And I think, again, I want to point, before I finish up here, I want to point your attention to the dreadlock, right? That was never followed up on, despite, again, Mr. Ogletree mentioning it 12 times in his interview. Hey, there's dreads on the floor. You know, that was crazy. Hair was flying. He says stuff, and he says something along the lines of, you know, people's dreads were all over the floor. You know, he mentions it many, many times, right? That was never followed up on. you see, when you watch that video, there are people everywhere, right? It's a crowded cell block, right? There's 200 people on it, we heard. There's people roaming around, walking back and forth. They're the dude in cell 2J2 right next door. He's leaning out of his cell while the state would have you believe that there's a violent assault happening next door, right? He told investigators he didn't hear anything. He's not here to testify. State didn't bring him in, right? I mean, he didn't hear anything. At least I would think that if he did, they would have brought him in to have him testify, right? I mean, there's people constantly walking past that cell. The only one who said anything, conveniently, Mr. Cummings' friend, right? There are other people. You'll see them. Watch the video, right? The guy in the green sweatshirt. There's a gentleman with a pretty big afro who stops by the door for a couple of minutes at one point. Where are these people, right? What do they have to say? What were their statements? Why weren't they here today, right? If Mr. Ogletree did, in fact, right, participate in this robbery, injure this man that ultimately led to his death, right? Why were all of these people not brought in here, right? This isn't a case where, hey, we don't know where they are. We know where they are. They're in prison, right? You could not have an easier way to track down witnesses, right? They're not here. Nobody else saw anything. The only person who points the finger at Ogletree is Akeem.
He fingered
right?
my client.
Cummings' friend. Take a look at the statements, right? They asked Mr. Ogletree, hey, why would Mr. Cummings, lie about that? Saying, hey, he wants to get out of jail, right? Everyone wants to avoid trouble. But again, look at the evidence, look at the video, listen to the statements. You will have all of this available to you. Everything that was an exhibit, you will have available to you, right? Just like I said at the beginning of this case, look and listen. It is not as open and shut as the state would have you believe, right? Again, these are serious injuries that we don't know when they were inflicted. We don't know how they were inflicted, right? We don't know whether they happened at 7:10, 7:50, overnight. We have no idea. What we do know is the state is completely relying on information that they got from people who we can witness disposing of evidence, right? Mr. Ogletree received no property. He left that cell with no property. After the incident, he's walking around. It's not like he just spent the rest of the night in the cell. He's walking around, right? He goes down to the showers. He's walking around. He's talking to people. He changes clothes. If he was going to get paid out, ample opportunity to do that. He talks to Cummings more than once, right? Ample opportunity to pay him out, just like Mr. Wicker got paid out. Why does that not happen? Because Mr. Ogletree was not in on this scheme. He was trying to smoke, right? And so ultimately, ladies and gentlemen of the jury, look through the evidence with an open mind, look carefully and closely, and we would argue that at the conclusion, you must find him not guilty of these charges. Thank you.
Thank you, Mr. Brennan. Mr. Knippen? Thank you, Your Honor.
So what you talking about?
Ladies and gentlemen, this is not a complicated case. You just need to use your common sense.
I'm really interested in seeing these two
When the
bicker in the back.
defendant and Mr. Cummings entered the cell at 2J3, Mr. Wetherington was alive, he was healthy, and he had been standing at the door just moments before. 14 minutes later, when the defendant and Anthony Cummings leave that cell, they are covered in the victim's blood, and Mr. Wetherington is incapacitated on the ground, unable to get up, move, or even talk. From that moment on, Mr. Wetherington never again shows any signs of life. This is not complicated to figure out what happened. You know exactly what happened in that cell. And all of the evidence establishes beyond a reasonable doubt that both Cummings and the defendant violently assaulted Mr. Wetherington and stole his belongings. When you're evaluating this case, I want you to consider the different types of evidence that the state has presented. And there are three different types of evidence that were presented in this case that are really undisputed. And that is the video evidence, that is the medical evidence, and that is the forensic evidence. And so when you're considering everything else, when you're considering the testimony of the witnesses or the story of Mr. Ogletree, I want you to evaluate it through that lens and see how it matches up to really the undisputed evidence, the evidence that's not really contested, which is, again, the video evidence, the medical evidence, and the forensic evidence. Because the video evidence, that's number one, it establishes a timeline in this case, and it conclusively establishes who entered cell 2J3. But not only does it establish a timeline, it shows you the movements and the locations of everyone involved in this case. Ms. Nicholson went through that with you. And so I'm not going to rehash all of the different movements throughout the process, but we know that the video evidence is undisputed because it speaks for itself. The second type of evidence that's undisputed is the medical evidence. This includes the autopsy results and the injuries that were sustained to the victim. You yourselves were able to view and see the injuries that Mr. Wetherington had. And you heard Dr. Brown testify about all of those injuries that the victim had sustained. Multiple blunt force trauma, to include blunt force trauma to the head, bruising to the face, neck, lips, and scalp, abrasions to the forehead and lips, lacerations to the scalp, internal bleeding around the brain, contusions to the chest and the abdomen, bruising to the right forearm and thighs, abrasions to the right arm, right knee, and right leg, as well as signs of a strangulation, including petechiae surrounding both eyes, and bruising to the anterior neck, and bruising even to the internal soft tissue of the neck. So again, that's another type of evidence that's not really in dispute. You heard the testimony from Dr. Brown. And then the third type of evidence that's not really in dispute is the forensic evidence or the DNA evidence. And the forensic evidence establishes that both the defendant and Cummings had the victim's blood and DNA all over their clothing. You saw the thermal pants that Mr. Ogletree was wearing, and you saw the sweatshirt of Mr. Cummings. You saw those blood stains, and you heard forensic scientist Catherine Daly testify that those stains on the defendant's clothing had the victim's DNA on them. So again, think about that evidence. All of that evidence, undisputed. Video evidence, medical evidence, and forensic evidence. And the state would submit to you that if you just look at that evidence by itself, that is enough to prove that this defendant committed these crimes beyond a reasonable doubt. But that's not the only type of evidence that we presented. We presented one additional type of evidence, and that was eyewitness testimony. That eyewitness testimony was presented by Shaquiz Hakeem, Jason Addison, and Vincent Wicker. And here's what I want you to ask yourself when you're evaluating the eyewitness testimony of these individuals. This is what I think is important for you to be thinking about when you're trying to decide whether they're credible or not. I want you to compare their testimony and the statements that they made to the three types of undisputed evidence, to the video evidence, to the medical evidence, and to the forensic evidence. And I want you to consider, is their testimony supported and corroborated by that undisputed evidence, or is it contradicted by that evidence? And then we're going to do the same thing with Mr. Ogletree's statements and evaluate it through that same lens. So let's first talk about Shaquiz Hakeem. Shaquiz told you when he looked into that cell, 2J3, he saw the defendant on top of the victim on the first bunk, and that the defendant was punching him and choking him. He also testified that he saw Cummings punching the victim and looking out the window to see if anyone was coming. So you first have to ask yourself, when you're evaluating Shaquiz's testimony,
Was Cummings
did
coming?
he even have an opportunity to see the things that he told you that he saw? And we know from the video evidence, as Ms. Nicholson showed you, he absolutely had the opportunity to see the things that he's telling you that he saw. You saw him go right up to that window, look directly inside, right, where he'd be able to see both beds and he'd be able to see exactly what was happening in there. So his testimony is supported by the video evidence when he's telling you that he was looking inside of that cell. So then I want you to ask yourself, is his testimony also supported by the medical evidence, i.e. the injuries to the victim? And this is how I think you can actually tell and know for certain that Mr. Hakeem was telling you the truth. And you can know that because he told you from the witness stand, he told Trooper Creech the day after this incident occurred that James Ogletree was on top of the victim and he was choking him. That James Ogletree was choking the victim. Shaquiz Hakeem would have no way of knowing that later on, when an autopsy was conducted on Mr. Wetherington, that there would be evidence of strangulation, that the victim would have petechiae, that he would have bruising to the external part of his neck, and also that he would have bruising to the internal soft tissue of his neck. Mr. Hakeem would have no way of knowing that. He is the only one that provides evidence of how those injuries to the neck of Mr. Wetherington would have occurred. And so that's how you know you can believe his testimony, because it's supported by the video evidence and it's supported by the medical evidence. But not only that, it's also then supported by the forensic evidence. Because if you believe Shakiz's testimony, it would make perfect sense then why Mr. Ogletree's would have the victim's blood all over his clothing. So when you look at the undisputed evidence,
Good Lord.
Shaquiz Hakeem's testimony is supported by all three types of that undisputed evidence.
Easier than most women. Simmer down, Ogletree.
The defense wanted to talk about, well, he got an opportunity to review his video before he testified. But think about that. That's not unusual at all. If anybody sees an event and they give a statement to the police, and then 2 years pass before they have to come into a courtroom and swear under oath that what they're going to tell is the truth, anyone would want to see that statement that they made 2 years prior to make sure that it's the same and consistent and that they remember everything that they told the trooper. That's not unusual at all. Think about if any officer, now all the officers have body-worn camera, and the officers have the ability to access that camera. If a case takes 2 years to be presented to a jury, an officer would go back and review that body-worn camera because they want to be accurate. There's nothing unusual about that at all. It's not odd that someone would go back and watch that testimony before coming in and testify. But remember, he made those statements the day after this incident occurred. And one of the jurors asked a question like, were those statements consistent? And Trooper Creech said that they were. Now let's talk about Mr. Addison. He told you that he was not in the cell when this occurred, and that Anthony Cummings approached him and told him he needs to go check on his cellie. And he told you that he opened the door and that he saw the victim beaten and unconscious lying on the floor. He later told you that after he exited the cell, Mr. Cummings asked him to help clean it up, and the two of them went into the cell together and lifted the victim up onto the rack. Again, all of this testimony is supported by the video evidence. You see when Jason Addison first walks into that cell at 7:57, you see him come back and you see him and Anthony Cummings then enter that cell later, I believe at approximately 8:12. All of that is captured on video. Everything that he's saying lines up. But not only is his testimony supported by the video evidence, it's also supported by the medical evidence, because Mr. Addison talked about the victim being knocked out and unconscious and never showing any signs of life during their entire interaction. This is consistent with the medical evidence and the injuries we know that the victim sustained, as testified to by Dr. Brown. And how else do we know that Jason Addison was telling you the truth? We know that because just 10 minutes after he entered that cell for the first time, He is on the phone with his girlfriend talking about how two dudes just went in there and fucked up his cellie. Think about that. Just 10 minutes after he enters that cell, we have him on a recorded phone call talking to his girlfriend, telling her exactly what it is that he saw. That's how you know that Mr. Addison wasn't involved. The video evidence confirms he wasn't in the cell at the time of the attack, and the phone call that evening to his girlfriend confirms just how badly the victim was beaten by the defendant and Mr. Cummings. So Mr. Addison's testimony is supported by the video evidence, it's supported by the medical evidence, and it's supported by the recorded phone call that he made to his girlfriend. And Mr. Addison's testimony tightens that timeline, doesn't it? Because we know the video evidence, from the video evidence, that after the defendant and Cummings leave the cell at 7:17, no one enters that cell until Jason Addison goes in at 7:57. And then just 10 minutes later, we have that recorded phone call to his girlfriend where he's telling her exactly what he saw. To think that Jason Addison was involved in this, you would have to think that he was smart enough to think all this through and plan all this out, to place this phone call to his girlfriend when he was secretly involved in this, or secretly somehow went back in later on or overnight and attacked the victim. That's not realistic. Jason Addison is not that smart. He's not going to come up with that, ladies and gentlemen.
Ouch.
Now, what is Jason Addison's
I have
fault?
feelings.
What
sir.
is his flaw in all this? There's no question. Jason Addison, over the course of that night, should have alerted a CO, should have done a better job to get a CO, to get in there and help Mr. Wetherington and see if he could have been revived at that point. That's a fact. There's no getting around that. He should have done better. That was a moral failure on him.
Kat says, is it that unbelievable to say something on call you know is recorded? Yeah, of course. It's literally the reason the defense cannot bring in their own out-of-court statements, because it's considered self-serving. It's a self-serving statement. It's not an exception to hearsay. But yeah, I think the roommate was fairly credible. I mean, not very brave, but credible.
His part, and he failed at that. But that doesn't change what this defendant and Anthony Cummings did to Mr. Wetherington. Finally, you have the testimony of Mr. Wicker, and he stated that he was asked by Mr. Cummings to watch the door and alert them if any COs were approaching. And he told you that when he knocked on the door, he looked inside and he saw three big dudes in there tussling. Again, even his evidence or his testimony is supported by the video evidence. You can clearly see him acting as a lookout. You can clearly see him knock on the door and look in, and then you can see him walk away. Was he more involved? I don't know. But we know from the testimony that everything that he told you is corroborated by the video evidence. So the testimony of all three eyewitnesses are supported by the undisputed evidence, the video evidence, the medical evidence, and the forensic evidence. One other thing that I think is important to mention is the risk that these individuals took by coming in here and testifying to all of you. There's been testimony about a code and a culture, and you're not really supposed to snitch. But these individuals, all three of them, the day after this incident, they came in and they told Trooper Creech exactly what they saw. But not only that, they came into this courtroom and they got up on that witness stand in front of Mr. Ogletree, and they told you the same thing that they told Creech back on December 7th about what they saw. They took a real risk by coming in here and testifying. They're breaking a code when they do that. You're not supposed to do that. And you could tell especially from Mr. Hakeem, and you could tell from Mr. Addison that they did not want to be here. They said that. Mr. Hakeem said, I don't want to be here. And you could tell from Mr. Addison how scared that man was when he was testifying. But what did Mr. Addison tell you? He said that he was doing it because what he observed and what he saw, what they did to Mr. Wetherington just wasn't right. So he came in here and at his own peril, at all of their own peril, they came in here and testified truthfully about what they saw. Mr. Brenner talked a lot about this dread that could have, should have, would have been collected. Should the Ohio State Highway Patrol have collected that, what appears to be a dread? Yes, absolutely, they should have collected that. Is there anything that we can do about it now? No, there's not. Do we know whose dread that was? We don't. They all three had dreads. It could have been Mr. Ogletree's dread, could have been the victim's dread, could have been Mr. Wetherington's dread. But even if we knew whose dread it was, it doesn't change anything from the state's perspective, because this was a beatdown. The two of them went in there together. They assaulted the victim together. They both have the victim's blood all over their clothing. So whether Mr. Wetherington, while he was trying to fight back, was able to pull Mr. Cummings' dread off, or whether he was able to pull Mr. Ogletree's dread off, or maybe one of them pulled Mr. Wetherington's dread off, it doesn't change. It doesn't matter. It doesn't change what happened to Mr. Wetherington in that cell. So I wouldn't get too focused on the dread. The other thing that I want to touch on briefly is this aggravated robbery and the idea that Mr. Ogletree didn't get anything. Whether he got anything or not is not important to whether he was complicit in committing the aggravated robbery. If Mr. Cummings is able to get the victim's commissary bag and walk out of it, and walk out of the cell with it because of the assault that Mr. Ogletree and Mr. Cummings had put on him, or whether because Mr. Ogletree was still assaulting the victim at the time that Mr. Cummings walked out of the door with that bag, that's complicity to aggravated robbery. So it doesn't matter whether he got something, whether he didn't get something. If by aiding and helping and encouraging and by assaulting the victim, Mr. Cummings was able to walk out of the cell with that bag, he is just as guilty of the aggravated robbery. And the last things I want to do with you, ladies and gentlemen, is I want to go back to that lens through which I'm asking you to look at every piece of evidence in this case, compared to the video evidence, medical evidence, and forensic evidence. We did that with the state's witnesses. Now let's do that with Mr. Ogletree's story to the detectives, or to the troopers. If you remember, during that first interview with Trooper Klons, the defendant stated 3 critical facts that I want you to pay attention to. First, he stated he did not enter the victim's cell after lunchtime. He was asked several times about that in several different ways, and he says, I did not enter that cell after lunch. And we know, well, we'll come back to that. The second fact is, he stated that the victim was just epping and that there was no fighting while he was present in the cell. And third, he confidently stated that the victim's blood and DNA would not be on his clothing. So those are 3 statements that he made. There was no fighting, there would be no blood on his clothing, he wasn't in that cell after lunch. Now let's compare that to the undisputed evidence that we know in this case. We know that the statement about I wasn't in that cell after lunch was false. We know that from the timestamp on the video. He was in there at 7:04 p.m. So that was a false statement right away that he made to the police. So the video evidence contradicts what he said. Second, the medical evidence shows that he was not being truthful. There's no way that that victim was just epping and falling over, and that's what caused all of these injuries. You heard Mr. Brenner try to ask that a bunch of different ways to the coroner, to Dr. Brown, and be like, well, if he fell, if he was epping and he kind of fell out of bed, could that have caused it? And Dr. Brown was adamant. She's like, that couldn't have happened because of the constellation of injuries. Because he was beaten so badly, we're not talking about a single injury. We're talking about injuries to all over his head. You're talking about injuries to his body, to his chest, to his legs. And you're talking about injuries to his throat where he was strangled. This wasn't a situation where this person was just epping and fell over a couple of times. This was an assault. And Dr. Brown's testimony confirms that this was an assault and shows that Mr. Ogletree's statement to the police is unquestionably false. And then the last thing that shows that his statements are false is the forensic evidence. He was adamant. There is no way that that victim's blood is going to be on my clothing. Not his blood, not his DNA. Felt pretty confident saying that because he had changed his clothes because he knew that his actual clothes that he wore during the assault were in his trash can. He didn't know that the troopers were going to go and find that clothes in his trash can, which unquestionably showed blood all over his pants and on the top of his sweatshirt. So again, his initial statement to the police is contradicted by all of the undisputed evidence. It's contradicted by the video, by the medical, and by the forensic evidence. And now Mr. Brenner wants you to believe, well, maybe he just wasn't telling the truth because he was afraid of snitching. He didn't want to get hurt. Ladies and gentlemen, there is no evidence in this case of that whatsoever. In fact, the only evidence that we have completely refutes that. Because if you remember, when Mr. Ogletree was asked if he was afraid of fighting anybody in the jail or in the prison, he said that he wasn't. He says nobody messes with him. Nobody fights with him. He's 6'3". He is a big dude. He made it sure that he could handle himself. So he's not worried about coming back and somebody being mad at him for giving a statement to the troopers. Now let's talk about the second interview, where the defendant continues with his lies, still claiming initially that the victim was Epping. But it's not until Trooper Butler and Trooper Creech start pushing him and start talking about all of the other evidence they had. They start talking to him about the video evidence, the blood on the thermals, and the injuries from the autopsy. And as the defendant is confronted with this mountain of evidence against him, he, at the very end of that interview, tries to gently point the finger at Anthony Cummings. And he claimed that Mr. Cummings was tussling with the victim and he himself was just in there smoking too. But even think about that and whether that story makes sense. Think about the injuries that you know that the victim suffered. That was a complete beatdown that Mr. Wetherington suffered in that cell. And apparently, Mr. Ogletree wants you to believe that while Anthony Cummings was assaulting him and causing every single one of those injuries to Mr. Wetherington, he's just off in the corner, smoking his tune, getting high. Does that make sense? Is that logical at all? Of course not. And then this is the most offensive part. He wants you to believe that as Mr. Cummings exits the cell and he takes the victim's commissary bag, we know that he's in there for 3 minutes, 3 additional minutes. But what does he want you to believe that he was doing during those 3 minutes? He wants you to believe he was the one that was helping him. I was concerned about Mr. Wetherington. I was trying to help him and get him up and take care of him. That's absurd, ladies and gentlemen. It defies all reason and common sense. But don't get me wrong, it's smart to try to pin this on Anthony Cummings if you're Mr. Ogletree. Cummings was definitely involved. There's no question about that. He stole the commissary bag while the defendant was still in there assaulting the victim. But to try to suggest that Cummings did this alone begs absurdity when the video evidence shows them hanging out before and after the assault, and both of them are covered in the victim's blood. And remember, we don't have to prove that James Ogletree acted alone in this matter. We don't believe that's the case at all. It's the state's position that they were working together. And that's why you're going to be instructed on complicity. Because complicity, under that theory, the defendant is just as guilty of all of these offenses if you believe that they were working together and that the defendant was encouraging, supporting, or assisting in any way all of these offenses that were committed in the cell. Ladies and gentlemen, as I told you at the beginning, this is not a complicated case. The victim was alive and well before being confined in that cell for 14 minutes with the defendant and Cummings. Both the defendant and Cummings then exit the cell covered in the victim's blood. And the very next person to find the victim, Jason Addison, finds him beaten, bloodied, and unconscious on the cold concrete floor. Use your common sense. Evaluate all of the testimony and evaluate the defendant's stories through that lens of, is it consistent or contradicted by the undisputed evidence in this case, by the video evidence, by the medical evidence, and by the forensic evidence. And once you do that, you will come to but one conclusion, that the defendant is guilty of felony murder, felonious assault, and aggravated robbery. Thank you, ladies and gentlemen.
Apparently, we approached very quickly.
Yes. You have heard the evidence and the arguments of counsel.
Okay. All right. So, 93% guilty. 7% hung jury. 0% not guilty. Sufahella. All right, let me see here. Skip forward to the verdict. Do-do.
Evidence, you should try to resolve the issue based on the collective habits to consult on the justice of in fulfilling your diligence or anyone on my staff has said.
Process.
The pants, the sweatshirt, and the blood card.
Up with a hand to the request that they want to see it. Then I will send back, obviously, the gloves and stuff with the handling of that evidence. Any objection to that?
No.
No, you're just talking about
The
the
gloves
pants, the
fit?
sweatshirt, and the blood card. Right?
Yes, sir.
Yeah,
Those three.
No objection.
Okay, so if you guys want to physically see that and not just look at the photograph, we can make that happen, but I want whoever handles that to be wearing the gloves, okay? Just like you saw with the gloves. The other thing is the transcripts.
Did you learn
of
nothing from
of the
OJ?
interviews of the defendant. And that
Come on, let's go. So yeah, they were out for a few hours, I believe.
All right, Mr. Knippen, anything on behalf of the state?
There.
Mr. Brenner?
No.
All right, Justice got your number up, sure.
Yes.
Okay, thank you.
Oh, she's got your number.
sir.
I think this is the verdict here. Wait, maybe not. 1 hour and 19 minutes. Oh, thank you, Kay. You're the best. I don't think so, Jim.
Or eyes.
They can ask questions to the judge. Really? Yeah, because the family's not there. He didn't wait a few minutes? Wow. That's kind of surprising. Because Ohio's pretty strict with the victim's rights. Yeah, I'm sure he didn't say tough shit, but wow. Okay, interesting.
Thank you. Please be seated. Mr. Bramlage, I see you're holding the forms. Are you the foreperson of the jury? Can you tell me, has the jury reached a verdict?
Yes, we have.
Could you please hand the verdict forms to Mr. Laux? The matter of the state of Ohio versus James Ogletree, as to count one, we, the jury, being duly impaneled, sworn or affirmed, find the defendant James Ogletree guilty of murder as he stands charged in the indictment. This verdict form is signed by all 12 members of the jury.
Oh, he's
As to count two, we, the jury, being duly impaneled, sworn or affirmed, find the
pissed.
defendant James Ogletree guilty of felonious assault as he stands charged in the indictment.
Wow.
This verdict form is signed by all 12 members of the jury. And as to count three, we, the jury, being duly impaneled, sworn or affirmed, find the defendant James Ogletree guilty of aggravated robbery as he stands charged in the indictment. This verdict form is signed by all 12 members of the jury. Does the state wish to have the jury polled?
No, Your Honor.
Does the defense wish to have the jury polled?
No, Your Honor.
All right, ladies and
Oh, come on,
gentlemen,
poll the jury,
that
dude.
concludes your service. You have the court's thanks. I think Ms. Burnside wanted to talk
He
to
is,
you for a
like,
little
that's
verdict
weird.
form is guilty.
And more of a
And
reaction.
James Ogletree guilty of felonious assault. As to count one, we, the jury, being duly impaneled, sworn or affirmed, find the defendant James Ogletree guilty of murder as he stands charged in the indictment. This verdict form is signed by all 12 members
That's
of the jury.
interesting.
As to count two, we, the jury, being duly impaneled, sworn or affirmed, find the defendant James Ogletree guilty of felonious assault as he stands charged in the
Well, I
indictment.
do like that he was
This verdict
invested.
form is signed by all 12 members of the jury. And as to count three, we, the
Yeah.
jury, being duly impaneled, sworn or affirmed, find
Well, that sucks for him. Wonder if he's rethinking not testifying. Oh, I'm sure. Yeah, he's already doing a 20-year. He was going to get out in like, oh yeah, it was 20 years for manslaughter. He was going to get out in like 43. Imagine it's going to be a little later than that now. That has to be something that just, once you're convicted, like every little thing every single day would just be going through my head. Like, should I have testified? Should I have done this? Could my lawyer have called this witness or that witness? Sarah Boone's probably sitting there thinking, I could have been out in 3 more years if I'd just taken that goddamn plea deal. So yeah, let's do the sentence. That's not too long. So sentencing was the next day.
This is case numbers 22CR397573 council LC violation hearing.
He sprinkles other cases in throughout the day or in the morning before trial or whatever. So sometimes I get them. I snag the whole day and try to edit out the breaks and everything, but it takes a little while to. Sometimes I miss some of them.
This is case number 24CR42028, the state of Ohio versus James Ogletree. Mr. Ogletree is before the court with his counsel. Mr. Brenner, Mr. Knippen, Ms. Nicholson, on behalf of the state of Ohio, we're here for sentencing. You wish to be heard on the issue of postponement continuance.
I did, Your Honor. I know we had some conversations back in chambers since yesterday, and I just spoke with my client here again to confirm. I have had contact with my client's family. He has a sister that's called me. I've spoken with his paramour. They are indicating they would like to be present. They are coming from the Cleveland area. They were not able to be here today.
Paramour? Is that the professional court way to say baby mama? I mean, I don't mean to be offensive, but I don't understand why he said paramour. Like girlfriend, the mother of his child, his hooker. I'm just thinking, like, paramour is side lover, so it's like Game of Thrones-esque. Like, it's a very old-timey term that I know what it means. It's just I don't understand why he used it here. Oh, bye, Erica. Oh, yeah. She did, Kat. She did use paramour to describe a girl in the YSL trial. It's so weird. Well, her boss knows about being a paramour.
Told them I request a continuance. They indicated they'd be able to be here on Monday or Tuesday of next week. And so I am placing that request on the record. I understand logistically there's another family involved, and I understand that, but I did want to make that request for the record. And further, I've been discussing with my client. He's requesting that the court complete a PSI.
State wish to be heard on that request.
Your Honor, the victim's family is present. They would like to go forward with sentencing today. So would the state. They've been here throughout the entire week for this trial. And I think that there's no reason that this should be postponed. The state's prepared to go forward with sentencing today, and we request to move forward.
All right, that request is denied. We will proceed with sentencing now. I don't see a need for having a pre-sentence investigation. The court has sat through the testimony of this case the court is aware of Mr. Ogletree's prior record and his current prison sentence, so I don't see a need for a pre-sentence investigation. So that request is denied. We are here for sentencing. We've just sat through 3 full days of a jury trial. The jury has returned a verdict of guilty on all 3 counts from the indictment. Does the state wish to be heard before I sentence Mr. Ogletree?
Yes, Your Honor. A couple of things first. It's my understanding, and I believe everyone agrees, that count 1 and count 2, the murder and the felonious assault would merge. The state would elect to proceed on count 1, the murder. And so the court then will be looking at the murder with the repeat violent offender specification and the aggravated robbery with the repeat violent offender specification. And then I would like to make a brief statement, and then the victim's mother, Tamika, would also like to address the court. Your Honor, I think what's important to note here is that the defendant is 30 years old, and he is currently in prison for numerous crimes, to include attempted theft, failure to comply, robbery, receiving stolen property, harassment by an inmate, theft, disrupting public services, theft, attempted theft, vandalism, firearms in a motor vehicle, B&E, and also involuntary manslaughter, which my understanding was a murder charge that was pled down to involuntary manslaughter. And his
But was there any theft charges?
current outdate is not until 2043. So just the number of crimes he's just in prison for now at the age of 30 speaks volumes. And I know the court has sat through 2 trials in this case and is well aware of all of the facts, so I don't want to rehash those. But I do think what's important for the court to think about, and what struck me in watching the videos, is immediately after this violent assault, where he caused all of those injuries that we saw to the victim, you see the defendant on camera, and he did not care. The complete depravity of the defendant's attitude towards beating a man like that, to the point that he lost his life, and he's walking around the cell joking, laughing with other inmates. At least with inmate Cummings, there was some testimony that he seemed to be worried about the condition of the victim or how he was doing. With defendant Ogletree, it is clear from that video that taking that man's life meant nothing to him. And so because of that, I don't think there is any reason that someone like that should ever be out walking amongst society again. And so the state would be requesting that the court impose the maximum possible sentence. And then Tamika would like to make a statement to the court as well.
Oh, this is going to be sad.
Your Honor, no words can truly capture the depth of my pain and the void left in my life. After the loss of my son, Marquise Wetherington, he was more than just my child. He was my firstborn, pride, my joy. While he has made mistakes in life, he still had dreams, hopes, and so much life ahead of him. And all that was stolen in an instant. The day I learned my son had been murdered, my world shattered. Every day I wake up with a hole in my heart. I can no longer hear his laughter, hug him when I need comfort, or see I wake up with a hole in my heart. I can no longer hear his laughter, hug him when I need comfort, or see him achieve the change he wanted to make in his life. I live with grief, angers, and questions that will never be answered. The impact on my life and my family has been devastating. There are nights I cannot sleep because of the images that replay in my mind. Holidays and birthdays are no longer celebrations, but painful reminders of his absence. Even the simplest things like hearing his favorite songs or even looking at his son can break me. Your Honor, I want you to understand that my son was not just a troublemaker. He was a beloved son, father, grandson, brother, friend. His life mattered. He deserved the chance to live and grow and fulfill his potential, and was close to getting out and doing this. Because of this crime, that chance was taken away forever. I am left to live with the unbearable reality of his absence. I respectfully ask that when considering sentencing, the court recognizes the gravity of what has been taken, not only from me, but from everyone who loved him. The pain of losing a child to violence never goes away. My hope is that justice will be served and not that any other family will have to experience the kind of loss from these defendants.
Thank you.
Oh, she just
Mr.
gave him the
Knippen, is there
look.
anything else?
No, Your Honor.
Anything from probation? Mr. Brenner?
Thank you, Your Honor. A couple of things. First, I want to state that I know the court's aware throughout this case, I've spent a good amount of time with Mr. Ogletree. I've gotten to know him, gotten to know his family. And I think I can say definitively, this man is not a monster. I know that it was not his intention to hurt this man or his family. I don't know that we're ever going to know the full truth of what took place that day. But I think that Mr. Ogletree is being truthful when he said that he had no problems with Mr. Wetherington. I think it speaks to his character also. We spoke more than once about the victim's family and about him wanting the victim's family to know what took place and to know who was responsible. In fact, I think yesterday, when we were talking about waiting for the family to come so that they could hear the verdict, my client said, I think they have a right to be here. We were kind of whispering back and forth. And I know that this is a situation that has weighed heavily on Mr. Ogletree. He knows that regardless of whether the outcome of this trial, he's going to be in prison for decades. And I think we've talked, he recognizes that, and I'm not here to make excuses, but he's from the projects of Cleveland. He had a rough upbringing. He's had a lot of adversity in his life. Not that that's an excuse. I just want the court to be aware of that. And I think he recognizes that he needs to, and he wants to change and not be this person and not be associated with crimes or illegal activity or frankly breaking the rules in the facility. He wants to be the kind of person who is at peace with himself and at peace with other people. I think he's making progress in that direction. And again, I know the court's aware of kind of the progress of this case, but I think Mr. Ogletree has been respectful. He has been, obviously, I know there was a slight issue during the trial, but we had no problems whatsoever. And I do not anticipate there being problems in the future with Mr. Ogletree. Obviously, this entire situation was horrible and a tragedy, and we are so sorry to the victim's family. With that being said, Your Honor, this was nearly 2 years ago, and I do think that Mr. Ogletree has started to make that change that I was just speaking about, and that I know that he wants to do. And I just hope that the court recognizes that, takes that into consideration. Additionally, I will reiterate, I know the court's aware he's in prison currently until 2043. I would just ask the court to issue an appropriate sentence that would perhaps permit Mr. Ogletree in his old age to have some taste of freedom. And we just ask the court to consider that, and thank you.
Thank you. Mr. Ogletree, is there anything you'd like to say before I sentence you?
This is good.
Yes, Your Honor. First and foremost, I want to apologize to the family because I never got a chance to. Even though I'm not even going to sit and make excuses for myself. I just want to apologize because nobody deserved to be through that. And I was sorry. I'm sorry you would put you through this. I'm sorry. Sincerely, through my heart. And I know they brought up my record. I took accountability. I copped out to my actions. This one, I feel like the person who was really involved, he slindered away. So I wanted to take accountability. I did. I wanted to cop out. But I wanted the person who was really involved to take accountability first, because it was his actions. I never had a problem with your son, man. I'm sorry. I never had a problem with your son, man. I never even had no physical, I know you was familiar with Cummings shit. Like, boy, from the same city. He's told me he was friends with your son. Like, he's not to be trusted. And I want to warn you that because you deserve to know that. And I don't want to really say too much because some of my words behind him. I'm so sorry for your loss. And everybody over there, sorry for everybody lost. I didn't deserve that.
Wow. Well, she believes him.
But again, I took responsibility for my actions in those charges that I'm sentenced for. I took responsibility. I didn't want to make this all long, drawn out. I didn't want this for everybody that's present. I didn't want this. But I just feel like I was my back against the wall. And the person who brought me in the situation was putting it all on me. So I had no choice. I wanted to get on that stand and tell everything, but the consequences that I will suffer behind that, I can severely be hurt. So it's just like I was confused, Your Honor. I was confused. I didn't know. I was never this was a situation was really new to me. I never even was I told Brenner numerous of times I just wanted justice for the family. Numerous of times from the beginning to the end, I told him I just want if I do get on that stand, it's not gonna be for no jurors, not gonna be for nobody present but the family. If I do get on there, because I just want them to be understanding, but I feel like I would just save it to the end, or But at the end of the day, I'm already doing a long time in prison. I'm already doing a long time. I'm looking to get home, and I'm 50 something. So that's already deprived of my life. My children's life, I have children too. I'm already deprived from them. So I know they looking for justice, but I'm already deprived of my life. I'm already looking to come home old. I don't at this point, I'm thinking any time farther than that, I'm not even looking forward to coming home anymore.
Sit down, bitch.
So what do I do from here? I'm overwhelmed with so much at this point. I don't even know if I'm strong enough to stand behind that. But I don't know. I feel like I'm bad, Your Honor. So I just wanted to express myself to you before you sentence me.
All right, thank you, sir. It is difficult to imagine, Mr. Ogletree. I know that you are already serving a long sentence, and now the court intends to add time to that sentence. I honestly don't know how I can, in any way, no matter what my sentence is, provide comfort and justice to Mr. Wetherington's family. I just can't. They sat through 2 trials in this case. Mr. Knippen brings up a point which I was going to mention, is that after this, and the court does believe, after sitting through 2 trials and hearing from the jury yesterday, that you were involved in this, that you did in fact beat Mr. Weathering to the point of his death. I have no doubt about that. Your actions on the video immediately following that shows no remorse. I don't know how you could have how you could be involved in something like this and not be affected to your core that you've just taken a man's life. And this isn't the first time that you've taken someone's life. This is second time that you've killed another human being. And now you want me to have sympathy on you because your life is now ruined. You exterminated 2 lives from this world. They're gone. They won't come back. This lady will never be able to hug her son again. Forget that. Listen to me. You had a chance to talk uninterrupted by anybody. Now, if you have something else to say, I'll give you a chance. But once I start speaking, I do not expect to be interrupted. Are we clear on that?
I apologize.
Okay. Is there something else you want to say?
I apologize. When somebody try to tell you did something, and you ain't do it, it's hard for me to just.
Well, again, here's the problem, Mr. Ogletree. You can't in one breath say, I wanted to take accountability. I'm sorry for the family. And then in the next breath say, I didn't do anything. That's not how this works. So either you are accountable or you're not. The jury has spoken. The 12 members of that jury found you guilty of these offenses. So I quite frankly agree with the jury. So I'm not going to even dispute this with you. Is there anything else you want to say? And then after this, do not interrupt me again. Is there something else you want to say?
I thought you was giving me a time. Reason why I just was still talking because I thought you just asked me that same question.
I'm not asking questions. I'm making observations right now.
Your Honor, if I may, on behalf of Mr. Ogletree, I believe what he's intending to say, just based on my interactions with him, is he wanted to take accountability for his involvement, but he does deny being the one who beat Mr. Wetherington. I know that's
I understand that's what you're saying,
yeah.
but again, the jury has spoken. The facts have been decided by a jury, and quite frankly, based upon what I saw on the video of his actions following him leaving Mr. Wetherington's cell 2J3, the court, I find that incredible. I mean, I just do. So I won't go on any longer. We have exhibits, state's exhibits 92 and 93, which have been stipulated to, which show prior convictions of Mr. Ogletree. Court has considered the statements made here today, the purposes and principles of sentencing, the relevant seriousness and recidivism factors. And man, there's no justice that I can dish out today that's going to satisfy you. There's nothing that I can do. I cannot bring your son back, and you have the sympathy of the court. Court does find that counts 1 and 2 are dealing with offenses arising out of the same incident, and that they are allied offenses of similar import, and they will merge. Count 2 will merge into count 1, the state electing to proceed with sentencing on count 1, correct?
Yes, Your Honor.
All right. On count 1, the court will order that you serve a sentence of 15 years to life. On the repeat violent offender specification, the court will order you to serve 10 years, that to be served consecutive to the 15 years to life.
Okay.
On the aggravated robbery, the court will order you to serve 11 years to 16 and a half years in prison. That is the Reagan Tokes. And again, I'm not really certain, as I sit here today, how that interacts with the indefinite sentence on the life, 15 to life. I will order that to be served consecutive to count 1. And on the repeat violent offender specification, 10 years consecutive to the count 3 and consecutive to count 1 and the specification to count 1. Court finds that the consecutive sentences are necessary to punish this defendant and to protect the public from future crime. It is not disproportionate to the conduct or danger posed by the defendant, and these offenses were committed while the defendant was already incarcerated with the Department of Corrections. Now, on the aggravated robbery, you are subject to a mandatory period of post-release control, which means upon your release, the adult parole authority will supervise you for a period of 5 years. If you violate that supervision, you can be returned to prison for up to 1/2 of the court's original minimum term sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer, and that time would run consecutive to any additional prison time that you get sentenced to. You may be subject to supervision of the adult parole authority upon your release from prison for the remainder of your life pursuant to the revised code section 2967.13, but may also be granted final release from parole supervision no earlier than 5 years after being released from prison. You have been convicted of a qualifying violent offender offense as defined by Ohio Revised Code section 2903.41. Upon your release from prison, you are required to enroll in the violent offender database personally with the sheriff of the county in which you reside 10 days after being sentenced. If you're an out-of-state offender, you must enroll in the database personally with the sheriff of the county in which you reside or occupy a dwelling within 10 days of either residing in or occupying a dwelling in Ohio for more than 3 consecutive days, or residing or occupying in a dwelling in Ohio for an aggregate period in a calendar year of 14 or more days. You're required to provide the sheriff information, including your full name and any alias, your residence address, your social security number, a driver's license information or commercial driver's license or state identification card number issued to you, information regarding the offense of which you were convicted or pleaded guilty, the name and address of any place where you are employed, the name and address of any school or institution of higher education you attend, license plate number of each vehicle owned or operated by you or registered in your name, vehicle identification number of each vehicle, and the description of each vehicle, description of any scars, tattoos, or other distinguishing marks on your person. You are required to provide the sheriff fingerprints and palm prints. The sheriff will also obtain a photograph of you at the time of enrollment. After the date of initial enrollment, you're required
And
to
feed
re-enroll
pics.
annually. You must update and or amend any of the information described above that has changed and provide any additional information requested at the county sheriff's office within 10 days of the anniversary of the calendar date in which you initially enrolled. If you change your residence address during the 10-year enrollment period, you shall provide written notice of that change to the sheriff with whom you most recently enrolled and to the sheriff of the county in which you intend to reside within 3 business days of the change of address. You are required to comply with all of the above described requirements for a period of 10 years unless your sentencing court determines otherwise. Mr. Logston has a form that basically says the same thing that I just read to you, that I'm asking you to please sign for me, please, and your copy will be given to you.
Judge taking away his gun rights
Court
as
does
well.
find that he's indigent for the purpose of any fines, costs, or other financial
Thank you, Your Honor.
sanctions. And it's 0 days jail time credit as of today on this sentence.
It's nice he gets some. He
Now,
does
it's
get some.
possible on
credit.
the Reagan Tokes case for you to earn 5 to 15% against your minimum sentence for good behavior. The court has a right to deny your good time credit, and a hearing would be held to make that determination. Regardless of whether you receive good time credit, you will be released when you finish your minimum term sentence. And in this case, that minimum term sentence is really the beginning of the tail for the life sentence. I'm just reading this notification to you just to cover all the bases. The Ohio Department of Corrections might determine that you must remain in prison for bad conduct. The court is not involved in that decision. If you're not released when your minimum term ends, you will serve an additional specified period of time and given a new release date. You'll serve until that date unless you are again denied release. The process could repeat until you are released or you finish your maximum term, which again, in this case, is life. You do have a right to appeal both the jury's decision and this court's sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, that can all be provided to you at no cost. If you cannot afford an attorney, I will appoint one for you at no cost. Mr. Knippen, did I leave anything out?
Your Honor, just 2 things that just for the record.
Oh,
I know
God.
you indicated there was a stipulation to 92 and 93, which were the certified copies of the defendant's prior convictions. The court is making a finding of guilty.
I'm sorry, yes. Yeah,
regarding
based upon the stipulation and the findings of the jury, the court will make a finding of guilty with regard to the specifications for the repeat violent offender.
And then also with respect, I know you ordered the sentences to run consecutive to one another. That's also consecutive to the prison sentence that he's currently serving.
I'm sorry, yes, absolutely.
Thank you, Your Honor. That's all.
If I didn't say that, that was the court's intention all over. Yes. All right, anything else?
No, Your Honor.
Mr. Brenner?
Your Honor, I will, just to preserve it for the record, I will place an objection to indefinite sentencing on constitutional grounds.
Thank you. All right, anything else, sir?
No, not this time.
Mr. Ogletree, as I said, you have a right to appeal the court's decision of your sentence and the jury's verdict. If you'd like, I will have Mr. Brenner file that notice of appeal for you, and then I will appoint new counsel to handle your appeal if that's what your wishes are. You can let Mr. Brenner know before you leave. All right, anything else, folks?
No, Your Honor.
All right,
This
thank
time,
you.
Your Honor.
Scott?
Not at this time.
Okay. And Dina, you can have these back.
Well, the prosecutor's in a total failure, so there's that. I don't give a fuck, hair boy. What is the next case? That is a very good question. Louise told me about one. Still researching it, but it's not going to be till the 13th. So I'm looking for one for next week. There's been a bunch recently that are starting or about to start. Civil trial with Peeler. Yes, I did see one. I think it was next week. Prison guard trial starts Monday. Which one was that? Oh, New York State DOC case for the Brooks murder. Interesting. The other one I'm looking at for the 13th is another prison crime. So not going to spoil too much of it just yet, but it looks really interesting. Hopefully it'll go forward. Probably will. Yeah, what are you covering, Kat? What do you got going on? Kat is a good friend of the channel. She covered the YSL trial in out of Fulton County, Georgia. Did a great job covering that. That trial was a shit show. You can find Kat's link here. Please subscribe to her if you haven't. Very good content. And you got the Courtney Clenny trial for sure is coming up. Yes. Nice. Maybe a smaller trial before then. Courtney Clenny's going to be wild. But yeah, for me, there's a Peeler has a civil trial next week. I might do that. I'm sure I'll find one. Usually, already subbed earlier. Awesome. Ooh, Fannie Willis testimony on November 13th. That'll be good. MLS is going to be next. He doesn't start for 2 hours though. Need to buy a dress with a zipper to wear backwards. Oh, she'll never live that down. Yeah, MLS doesn't start for a couple hours, but he'll be going for a while, and I think this weekend he'll be streaming quite a bit. I'll redirect you over there a little early. Connor Johnson, please cover Judge Peeler's civil trial next week. I will look into that. There was a starts Monday, I think. Okay. Bianca Ellis. Yeah. I'm kind of liking these smaller trials. Just kind of the stuff that happens every day, but you don't really see because you see the long trials on like court TV or long crime that go for days or a week or two. And it's really not common at all. I mean, most trials, even murder trials, are 2-3 days. Oh, awesome, Connor. Okay. I will look into that then. Yeah, for sure. I really like covering trials that are interesting or kind of unique or have something interesting. Or did Kay say it? Oh, yeah, Kay. Okay, Mavka told me about that one. Your son has to go for jury duty. Yeah, I need to look into Bianca as well. And there's a lot, but I think the civil trial looks promising. Okay, guys, thanks so much for hanging out. It's been a lot of fun. This one was very interesting to see the difference, how Cummings got off, no pun intended, but Mafka. Ogletree went down for it. And it was the same set of facts, same case, same evidence, but it was two entirely different theories presented to the jury. The local counsel on the defense side is the media lawyer in Southwest Ohio, so I'm curious why he's on the case. Well, you've definitely piqued my interest. Let me make a note about that before I forget, because I am very scatterbrained. Okay. Thank you, guys. So I am going to end now. It was awesome to see this one through. You scatterbrained. Sentencing was pretty good, Mavka. He talks for a bit. So yeah, I'll keep doing the trials, one a week or so, and keep it going from there. Oh, it's a defamation. Oh, defamation, huh? Could be interesting. Okay. Well, I will see you guys later. Say hi to MLS when he starts in a couple hours. And I will see you guys back Monday at 10 a.m. for Courtroom Roulette. You have a great day, guys. Bye. I don't have an outro video, do I? Ciao.